Welcome to Forbes Solicitors Probate Question and Answer session. I'm Rachael Gibb and I'm a solicitor in our Wills, Tax, Trust and Probate team. I'm going to be interviewing my colleague Elizabeth Whitaker today on a number of matters relating to probate and the administration of estates. Elizabeth is also a special solicitor in our Wills, Tax, Trust and Probate team. She'll be answering some of the most frequently asked questions that we receive. If you do have any questions following this Q&A, please do get in contact with us. So our first question today is, what exactly is probate?
So a grant of probate or a grant of representation proves the authority of executors or personal representatives to deal with a deceased person's estate. If the deceased left a will appointing executors, those people need to apply for what is known as a grant of probate. If there isn't a will, generally the next of kin will apply for what is known as a grant of letters of administration. They're very similar documents and you apply to the probate registry for both. The grant of probate is a legal document itself, but the process of applying for the grant and then the onward administration of the estate is often generically referred to just as probate.
So do you have to apply for a grant of probate in all estates?
No, you don't, not always. So if a deceased only owned property jointly with somebody else, such as their spouse or civil partner, then generally that will pass automatically to the surviving joint owner without requiring probate. If the deceased didn't own a house and only had sole bank accounts holding less than around £50,000, then probate might not be needed depending on the requirements of the specific banks. If the deceased owned a house in his or her sole name, then a grant of probate is always required because this enables the executors to sell it or transfer it into the names of the beneficiaries. Probate is usually also required where monies in the bank exceed £50,000 or where the deceased held any investments. But again, this really depends on the requirements of the financial institutions.
Now, our next question is, what are the duties of an executor?
An executor is responsible for ensuring that the deceased estate is properly dealt with and their wishes in the will are carried out. The responsibilities can be quite extensive and they also carry personal liability, so it's important where it's appropriate to seek professional advice. So more specifically, as well as ensuring that the death is registered and the funeral's been arranged and paid for, an executor is also responsible for obtaining valuations for the assets and liabilities in the estate. They have to ensure that an inheritance tax the inheritance tax due is calculated using the correct forms and paid to HMRC, and then they submit the probate application to the probate registry. Once the grant's then been issued, an executor is responsible for collecting in the estate assets, selling any property or investments, and settling all outstanding estate liabilities from the funds. They then consider the income tax and capital gains tax position of the estate and account for those where it's necessary to do so. Following that, the executors are then responsible for distributing the estate to beneficiaries, and they really have to make sure that they keep full records and prepare a final set of accounts because they then have to account to the beneficiaries for what they've done throughout the administration period.
If I've been appointed as an executor in someone's will, do I have to act?
No, there's no legal obligation to act. There are two options available to you in those circumstances, depending on how strongly you feel about it. So firstly, you can renounce your rights to obtain the grant of probate. So that's completely taking yourself out of it. And you can do this as long as you haven't intermeddled in the estate or started dealing with the estate yourself. You have to renounce by deed, and then that takes you out of the process entirely. A slightly less extreme measure where perhaps you don't want to be totally excluded, but there are other people who are appointed alongside you who are prepared to act, and you kind of want to just sort of keep a bit of an eye on things and have the option to step back in later on if you need to. And so you can have what's called power reserved. So the remaining executors obtain the grant of probate and deal with the administration. But if you need to at a later stage, you can step back in and apply for a grant of probate if required to do so.
If I have a relative who has recently passed away, what should I do first when dealing with their estate?
Yeah, so the prospect of dealing with an estate can feel like a really daunting task, so it's important to take it one step at a time. So aside from dealing with the funeral, the first and most important thing to do is register the death. It seems quite obvious, but without the death certificate, you can't then go on and deal with the deceased assets. So to register the death, you need to contact the registry office, preferably the one that is most local to the deceased residents, and they will make an appointment to register the death. Once you have the death certificate from them, you then will be sending that off to banks and other institutions to notify them of the death. It's worth getting a few copies of the death certificate from the outset, because once you then means you can deal with lots of banks at the same time. You don't have to wait for the death certificate to come back. You'll then need to look through the deceased paperwork, ascertain what assets and liabilities there may be in the estate. And you might want at this stage to instruct a solicitor to assist you in dealing with the estate going forward, depending on how complex it is. And we would ask you at that stage to bring in any paperwork that you've managed to find.
Now, when banks are notified of a death, they will freeze the deceased's accounts. So how do I pay for the funeral?
So by law, funeral expenses take priority over any other expense in the estate. So even though the banks may have frozen the accounts, they will still release funds directly to the funeral directors if they're provided with a copy of the funeral invoice.
Generally speaking, what is the process for applying for a grant of probate?
So in order to apply for a grant of probate, we need to firstly obtain valuations of all of the assets owned by the deceased, as we've previously discussed, including, for example, bank balances, investment valuations and property valuations, and then also any liabilities in the estate, such as funeral costs, outstanding loans, mortgages and outstanding bills. We would then prepare the relevant inheritance tax return using those figures, calculate the inheritance tax due, if there is any, and arrange for that to be paid. We would then complete the application paperwork and submit it to the probate registry. It's worth noting that there are two different inheritance tax returns, a short form return for simpler, lower value estates, and a longer form return for more complex or higher value estates. There are also two additional inheritance tax forms which have to be completed, where you need to claim additional reliefs from inheritance tax, such as the transferable nil rate band from a deceased spouse estate, and also the residential nil rate band is a separate form for that as well. And a solicitor would be able to assist with the completion of any of those forms by themselves if you need them to help.
Our next question is, do I need to appoint a solicitor to deal with the administration of an estate?
It depends on a number of things. So where an estate is very simple, some people feel able to deal with it entirely themselves. Some people, however, find the prospect of dealing with an estate quite stressful and also quite emotional, and would prefer, for their own peace of mind, really, to hand the whole process over to the solicitor to deal with. And it's not uncommon for us, for executors to come and see us bringing a box of paperwork belonging to the deceased and handing it all over to us to deal with from start to finish. And a lot of people find it just a lot easier to do that. And we've got a lot of experience in dealing with large and small estates, and often people just find that a lot easier. Some people do feel that they want to deal with some of it themselves, but feel more comfortable asking a solicitor to deal with the legal documentation, for example, or the tax returns. And we're able to be completely flexible and tailor what we do around the needs of the individual client.
So is it expensive to appoint a solicitor?
This depends really on the complexity of the estate and how much you want to do yourselves. So the legal costs are paid from the funds in the estate, so it's not the executors that personally have to pay them. If we were dealing with the whole administration of an estate from start to finish, the cost depends on the estimated time it would take for the solicitor to deal with it. And we would provide you with a quote at the outset, having had an initial meeting for you and ascertain the complexity of the matter. If you want to instruct us for specific aspects of the process, such as just completing the grant application paperwork, we are able to do this for a lower fixed fee, depending on which aspects we're dealing with on your behalf. Where there are a number of executors appointed in an estate, or where executors live at a distance from each other, or from where the deceased lived, it can be helpful and actually more cost effective to appoint a solicitor, because they're able to coordinate everything centrally, liaise with everybody involved, and then and deal with the assets a little bit more efficiently if they're closer to them.
Our final question for today is how long does it take to get a grant of probate?
Once the application's been sent off to the probate registry, it can take around 3 to 4 weeks for the grant to be issued, where the estate is relatively simple and no inheritance tax is payable. Where the estate is taxable or is more complex, the timescale really depends on the workload of the revenue and the probate registry, and it's quite difficult to estimate, but it can take a few months for the grant to be issued for those sorts of estates.
Thank you, Elizabeth. That concludes our question and answer session on this topic. They are just a few of the most commonly answered questions that we receive when it comes to probate matters. If you do have any other questions, please get in contact with us and our team. Our details will be available at the end of this presentation. Thank you for watching.